When parties come to us and there's an allegation of abuse, we either get the victim or we get the alleged abuser. And when we do that, what we try to do is make sure that they recognize they have a right not to be harassed, not to be intimidated, not to be bullied, and that there's a separate statute that's been passed for that purpose. Whether or not they're getting a divorce, they could just have a dating relationship, not even be married. They can be in the same household. Those people should understand they have the right to be free of harassment, intimidation, assault, various other wrongful acts that can be conducted between two people who are in the same household. The statute is very important in that it protects victims of domestic violence, but I must say that sometimes, sadly, that statute can be used more as a sword than a shield. In the beginning of a divorce proceeding, a wife, or a husband for that matter, could be using that statute to get sole and exclusive possession of the former marital home, as opposed to being a real victim of domestic violence. Important to note, it's not just an act. It has to put the alleged victim in reasonable fear for his or her safety. So you can have harassment, but if it goes on and it's been going on for years, that won't necessarily constitute domestic violence. There has to be a real reasonable fear associated with it occurring again, and a need to protect that victim to make those temporary restraints permanent. Sadly, domestic violence is a very real issue in family law matters, and we encourage you, if you have any situation that even touches upon harassment, assault, intimidation, any of those various, if you feel uncomfortable in your own home, you may very well have a cause of action for domestic violence. And so we encourage you to come here to Davis and Mendelson to help us protect you and your children from future acts.